Thank you very much, Jack Straw, David Davis, for your time and giving evidence this morning. I wonder if, to begin with, you'd mind just briefly introducing yourself and then just setting out again briefly your sort of opening views on the issue that we are discussing. And can I start with Jack Straw, please?
Thank you, Mr. Chairman. Thanks for this opportunity. I'm Jack Straw, a Member of Parliament for Blackburn, and I'm here, I guess, because I was in the previous government Lord Chancellor and Justice Secretary when this landed on my desk, the issue of the Hurst judgment in 2007. I've set out my view about prisoner votes pretty fully, and I'm sure, Mr. Chairman, your committee's had a chance to look at those. I will also, if I may, circulate copies of the second of three Hamlin lectures, which I gave last autumn on the Human Rights Act in Europe, in which I go into more detail about my view about the nature of the rule of law and why the British Parliament is right to resist this invitation unilaterally to change the law about prisoner voting rights. And that runs into a question as to whether or not the United Kingdom signed up to this creeping extension of the jurisdiction of the European Court when we agreed the treaties. The answer is we didn't. No one's ever been able to point to any treaty provisions or indeed Council of Europe decisions, which it said that the court should move away from a classic, a narrowed definition of human rights into all sorts of other areas, witheringly exposed by Lord Hoffman in a lecture he gave in 2009. Mm-hmm. And in that, and because of that, and because of the failure of the European Court in Strasbourg to allow a proper margin of appreciation, we've run into this conflict. And it's one which is going to have to be resolved politically. And that's my last point, because as a distinguished predecessor of mine as Lord Chancellor pointed out, implementation action in respect of Strasbourg judgments is a matter for political decision and is not of a judicial character, is what he said, and I'll give you the source. Thank you.
Thank you very much.
Good morning, Chairman. Firstly, I apologise for my voice. I have a summer cold, so forgive me for that. I guess the reason I'm here, and Jack, and Dominic Raab, is the three of us effectively triggered this process by putting a motion to the House on this issue, which was carried by 230-something votes to 22. The reason for that, much as Jack has described, was a concern over two things. One was over the substantive issue of prisoner votes. I felt that our law was perfectly clear, perfectly valid, had stood the test of time, and there was no really serious challenge in the public mind to it, on the one hand. But equally important, I guess, it also highlighted this problem of the effect of the living instrument doctrine in the European Court of Human Rights, which was leading them to intervene in a whole series of areas, not just this one, which the original signatories to the Convention would not have conceived of, and we didn't conceive of. And a concern, a general concern, that there was no clear democratic mechanism for correcting that. Unlike any national court or court system, international courts don't have and I can think of no reasonable model at the moment, don't have a proper democratic override. So that's the origin of it.
Thank you very much. Can I quote to both of you the evidence from Lord Goldsmith? And he said, and I quote, he said, "We signed up in Article 46 to an obligation to respect judgments of the court in cases in which we were party. We have that obligation," he said. "The rule of law requires that when you have signed up to an obligation to respect that judgment, you must do so." I mean, isn't he right? Well, we did sign up to this convention.
This runs straight into the point that David was making. It's whether we've signed up to respect these judgments by which the court in Strasbourg has unilaterally decided to extend its jurisdiction. This is at the very heart of this issue, and it won't go away. And if we were to say, as it were, well, we've suddenly been persuaded by some sort of Pauline conversion that we accept the right of Strasbourg to make decisions over prisoner votes, there'd be another issue. I mean, they, as Lord Hoffman pointed out, they even asserted that the question of night flights into Heathrow was a matter of fundamental human rights. I mean, it's an important issue, but by no stretch of the imagination was night flights into Heathrow within the contemplation of the court. So we didn't sign up to this. And what the court is doing is setting itself up as a Supreme Court of Europe. We never signed up to that. What we signed up to was a jurisdiction in respect of a narrow but important concept of human rights about people's liberty. So, for example, we certainly signed up to there is jurisdiction over whether or not a man like Abu Qatada should or should not be deported to Jordan. Okay? Now, successive Home Secretaries, Conservative and Labour, however irritated they might have been about decisions, have always respected them. And if I may say of David, his record on human rights and concern for individual liberty is impeccable. I leave you to judge about mine, but, some people may say it's more questionable, but so we signed up to that, and what Lord Goldsmith's assertion does is to beg the question about whether we signed up to this. We didn't sign up to this, and there is every other Supreme Court in the world has some element of democratic override. Even the most powerful Supreme Court on the globe, which is the United States Supreme Court, is subject to a democratic override. It may be a complicated one, but if you don't like its judgments, then ultimately they can be overturned by constitutional amendment, and have been. Here, there is no possible means of overturning the judgments.
Yes, I agree with that. In simple terms, rule of law is not the same as rule by judges. And if I can refer you to an even more authoritative source than Lord Goldsmith, it's Costa, the president of the court in the Hearst judgment, who highlighted that, in his view, this was an inappropriate judgment for the court to make because it was veering into the area of political rather than legal.
I mean, is it, for you, this isn't really an issue about prisoner voting. This is an issue about the conflict of jurisdiction, essentially.
Well, look, I mean, I don't have an... Yeah,
they're both
important. Both important.
They're both important, but one wouldn't occur without the other, frankly. And if you pressed me and said which is the most important, I suppose I'd say the constitutional issue rather than the substantive. But they're both important.
Just to say, yeah. Look, I mean, I presided as Home Secretary over change in the law. I mean, the judges were heroically ignorant of what had happened here. They claimed that we hadn't considered the matter in the recent past. Completely untrue. It had been considered by the George Howarth Working Party, All-Party Working Party, in 1999. Recommendations were made, and a change of the law so that it didn't catch unconvicted prisoners, quite right too. More recently, there's been a recommendation so that it shouldn't catch people who've been detained under the Mental Health Acts. Fine. But as David said, if we asked to choose, then if this Parliament decided to change the law on rights of prisoners to vote, well, you'd accept that as a democratic decision.
Yeah. And if you were helping us as a committee, scrutinising this draft bill, what would your advice to us be to resolve this potential conflict with the European Court?
Well, I think if I were giving that advice, I'd say to the committee provide at least 3 options, one of which must include outright refusal, because that tests this issue to its extreme. And I'd also offer 6 months and 4 years, because those are the 2 others that have been debated. I do not believe they'll resolve the issue, but I think Parliament ought to debate that. I'd also say that the bill should address the issue of compensation or absence of compensation, because I think actually there's been a lot of red herrings about compensation which will be dealt with by primary law.
Agreed.
Okay. Can I just finally, on that point, before I call Lorelei Burt, just ask you, I mean, you say in your written evidence to the committee that the European Court of Human Rights is unable to enforce its own judgments or compensation awards against national governments, and you're saying essentially that they can't enforce them, so ignore them. I mean, wouldn't ministers be obliged to pay any compensation awards awarded by the European Court or the Council, the Committee of Ministers, simply because, regardless of the ministerial code, ministers would be obliged to obey international law.
Well, look, with great respect, it's a parody of the circumstance to say that Parliament and Government has ignored the judgment in Hurst. Indeed, we've paid huge attention to it ever since it came out in 2005. But where we are is, say, in a situation, to repeat myself, where we are challenging the unilateral extension of jurisdiction by the court. And if we don't, my view is, if we don't take a stand on this, at this point, we'll have to take a stand on another point. And we've got a lot of very distinguished people behind us, including the minority of the court itself, who all recognised that what the majority were about to do was to create a train wreck for the Strasbourg court. Now, this was a train wreck about which they were warned by their own senior colleagues. They knew it was going to cause a conflict. My judgment is it's for them and the Council of Europe to sort it out, not for us.
I agree with that. Thank you very much. Laura Ibert.
That's certainly a different view to what we've had, just sort of push it back to them and say, not our fault, we're sticking with Armenia, Andorra, Bulgaria, Estonia, Georgia, Hungary, Russia and San Marino. We're not siding or making decisions more along the lines of our more immediate neighbours like Ireland, where they've implemented it without, it seems, any problems at all, universal prisoner voting rights. And, we're more along those sort of countries than France, Germany, Ireland or the Netherlands. Do you feel that's a comfortable place to be? It just seems such an old-fashioned idea to myself, that we're very, very disparate, by the way, in our views, and I think we've been selected for that reason. I was one of the 22, for example, so we've got to come to a decision here, but I just feel that we're seeming to err on the less liberal side of the spectrum when it comes to comparing ourselves with other European countries.
Well, guilt by association is not something I recognise normally. Neither do most decent judicial systems. I don't care what those other countries say, but let me just give you a small exemplar of the fact that this is not an issue just for us. The morning after that vote, in which you voted with the 22, I had a call from a Dutch professor saying our government's worried about this too. There's been an international conference since then, in which Germans, Swedes, and Dutch all indicated concern. The past president of Germany has made a non-stop campaign about the problem of both this court and the ECJ overruling German law without any democratic recourse. So this is not something which you can just say, oh, well, you're like the Armenians. I don't know if the Armenians ever debate about it. I frankly don't care. This is an issue about British justice and maintaining the integrity of British justice. Full stop.
I mean, I agree with that. And your party was, in 1999, agreed with the view of the George House Working Party, which was to deal with the anomaly that unconvicted prisoners were denied a right to vote, which was plainly wrong. So that was dealt with, but they also confirmed at the time that the general ban on convicted prisoners from voting should stand. Now, your party is fully entitled to change its mind on this, but as David said, I'm not bothered about what other countries' views are. I'm bothered about this country. And to repeat myself, if the British Parliament decides by democratic vote to extend the franchise to a limited category of prisoners or all prisoners, well, so be it. That's democracy. I'll take one view, you'll take another view, we'll have a vote. There's nothing whatever, or should be, nothing whatever to do with Strasbourg. And David has described this as the right to vote as a civic right, which is part of a contract for citizenship. You have a right to vote, but in respect of this, you're expected to behave, at least to the point where you don't get jailed. If you get jailed, then for that period, but that period only, not for afterwards, you lose the right to vote.
So the logical conclusion to what I understand you're both saying would be that perhaps Great Britain should withdraw from the European Court altogether. You know, and we've had witnesses coming along talking about the effect that withdrawing or refusing to acknowledge the rulings of the court would have on British reputation in the world.
Look, let me just deal with this. Our reputation goes before us, and you can judge the high regard that the people abroad have for our reputation as a place which respects the rule of law and individual liberty by the extraordinarily large number of people who wish to come into the country, especially from European countries who don't quite subscribe to the rule of law. So I'm completely relaxed about that charge. What the Strasbourg Court and those who support its right over this area have got to engage in is this unilateral extension of their jurisdiction without any consent by the British Parliament. Now, when you talk to them about this, their eyes just glaze over, and then they say, dragons, beware if you dare to go into that territory. I've not called for us to withdraw from the European Court of Human Rights. And still less have I called for us to withdraw from the Convention. What has to happen is there has to be a change of approach by this court, which is partly judicial, but also, let's be clear about this, partly political, and where in any event, as Lord Irving made clear, the enforcement of its judgments is determined by political process, not judicial process.
I don't see it, can I just answer that one point? I don't see it as a logical extension of our position that we withdraw. We believe that the vast majority of the work of the court is good work, where it stays within the Convention as written. What we're arguing about is a small excursion beyond it, not just one, many, and it needs to be dealt with. You don't deal with it by withdrawing.
Okay, thank you.
But aren't you saying don't obey? And hasn't Britain always obeyed every single one of its international obligations throughout history? And this would be the sort of first time. It's not a matter of delaying implementation, it's a deliberate decision not to obey. Wouldn't that be a major departure for this country?
Well, whenever we crystallise this issue, there will be a major departure. And we've already precipitated some response from the Council of Europe. It was at the ISIA and the Brighton statements, which effectively agreed with us in their comments to the court. There's always going to be a point at which you just break the line. Nobody likes it. I don't like it, and Dominic Raab doesn't like it. You don't like it. But we have to, at some point, put our foot down and say, look, we have to resolve this issue. It is not the living instrument thesis is not appropriate to court that has no democratic override. Full stop.
Before I call Lord Delucky, I mean, on this living instrument, doesn't it have to be a living instrument, given that when it was signed in 1951, there was no emails, there was no... I mean, technology's moved on, society's moved on, the definition of marriage has moved on, family life has moved on. If you just interpreted the text like the text from a sacred document, it wouldn't reflect modern life.
Fine, then create a new treaty. Create a new treaty, if that is your view. I have to say that the court has made perfectly sensible judgments on, let's say, retention of DNA and a whole series of other issues which it could not have dealt with in 1952 because the technology was barely understood, let alone invented. So I don't agree. I think there comes a point where you've got to write a new treaty. Fine. But accept until then that the courts do not make up the law. This is a court, bear in mind, whose judges are drawn largely by political appointment from a range of countries with very different histories to our own. I mean, this came to its most stark extreme in the ruling on the Gibraltar shooting of the IRA bombers, when Britain got chastised, largely by judges who had grown up virtually under Iron Curtain environment and viewed the state as an evil body. So comprehension of the court is not so good of our country that I would trust it with actually writing new laws for our country.
Yeah, I agree with that. And if you look at the international law relating to the interpretation of treaties, you will see that
The Vienna Conventions.
Yeah, the Vienna Conventions, that the court has gone way beyond what is accepted norms in terms of how treaties are interpreted. Now, given the fact that they've, as it were, taken that punt on extending their jurisdiction, the responsibility for the consequences lies with them, not with us.
Thank you very much. Lord Dalaki.
Lord Jack Straw, you were the Home Secretary when at that time also included the responsibility.
I'm sorry, Lord Acton, could you speak
When
up?
you were the Home Secretary,
Yes.
it included also at that particular time matters relating to Justice Department,
Yeah,
which was
yeah.
formed later on. You then became the Lord Chancellor.
Yeah.
What I wanted to find out from you, that during your time as a Justice Secretary, and I quote here, you kicked the issue of prisoners voting into touch.
Yeah.
That's the expression that's given to me. If you believe so strongly that there would be no consequence in refusing to comply with the European Court of Human Rights, why did you conduct some of the inconclusive consultation, public consultation?
I mean, my judgment, political judgment, was I had no option. I mean, I didn't believe there'd be no consequences, by the way. I mean, of course there are consequences. But one of the consequences of the court making a judgment in an area which has basically nothing to do with it is that there is no consent for that judgment within the British House of Commons. So, therefore, there is no majority to implement the judgment. So I was faced with a situation before the election where there was absolutely, whatever I said to the House of Commons, had done the numbers. I mean, not just with the Conservatives on the other side, but with my own side. They were very clear. Wild horses would not have got a majority into the I lobby in favour of a change. So, Lord Duckbear, what was I, apart from the fact this is my own judgment as well, what was I supposed to do? I mean, I'd be perfectly open about this as I was before. We didn't want this turned into a nasty pre-election issue. I would have found it incredibly difficult to argue in favour of prisoner voting when everybody knew my opinion was against it. So that's why we had one consultation, which I think was going on when I became Lord Chancellor, and when that was inconclusive, we had another. There we are.
But doesn't seem to you less than honest to conduct that sort of exercise when your own intention was not to comply with the ECHR?
No, I mean, look, ultimately, this is not to do with me, it's to do with the British House of Commons. If it turned out I was, to repeat myself, in a minority in the British House of Commons, that would have been the end of it. But palpably, was not in a minority, and I made that judgment. If it had turned out that this was, my view was a complete aberration, so just within the Labour Party. I mean, there are some issues, I'm trying to think what they are, but where my view was regarded as totally eccentric to the Labour Party as a whole. Well, the whips would have said to me, or the Prime Minister, too bad, Jack, you either stay in the Cabinet and implement the majority, or you leave. But this was not it at all, quite the reverse.
And where do you stand today if you have the options of 3 options that have been laid down to us, 6 months, 4 years, or indefinite? Where would you stand?
Well, I support what Mr Davis has said, which is that I think one option has to be we're not implementing this judgment, so 0, and then perfectly happy, I don't agree with them, 6 months, 4 years.
Can I ask Mr Davis, can I just say that your record of liberty and rights is a very important one and very useful one, because you actually resigned your seat at one time. And I find it very difficult to reconcile what you are saying now as against what you said when you were standing as standing for re-election. What I wanted to find out from you, you quite often talk about public opinion. How do you measure that? Were there any conclusive exercise which actually determines what the public opinion is on this issue?
Yeah, the numbers vary, but they range from about 63% of the public being against any change up to 76%. With all these things, depends how you ask the question. Right? If you ask the question, you say, do you want no change, 6 months, 4 years, whatever, you tend to get a lower number. You get the 63% against, but it's still a pretty sizable proportion against. And if anything, it's tightening over time. I can send you the numbers if that's helpful. But at the end of the day, if the public opinion was 100% the other way and I thought it was wrong, I'd go with my own view on this,
Yes,
as you saw in the by-election.
Can I, in that case, ask you, what detriment do you see if prisoners have a right to vote? What is it going to affect?
Well,
is it going to affect the political process? Is it going to affect the public generally? What is it going to happen if out of 70,000 prisoners, about 20, 30,000?
The operational effect on who gets elected will be almost zero, I should think. But that's not the point. When we started out, the chairman started out by asking whether it's a fundamental right. We said a civic right, and that's part of a contract. You know, the contract on the one hand is that we get to choose those who make the law. The corollary of that is we pay our taxes, which aren't all spent on ourselves, they're spent on other people. We maybe serve in the army and put our life at risk for the state, and we obey the laws. That's the other part of the contract. And if we break that contract on our side, we lose the civic right. It's as simple as that, in my view, beyond a certain level of seriousness.
Both of you have a very good record in talking about rehabilitation of offenders.
Yeah.
Don't you think this particular exercise in granting right to vote to inmates, prisoners, would actually help towards that exercise?
No, not really. Operationally, I think it would make no difference. I mean, we both of us would like to see much more effective, I think, much more effective rehabilitation. For my own view, Jack may not believe this, I think most of the attempts so far by the state to make rehabilitation work have failed, or not worked very well, put it that way. And the ones that have worked because they're really quite tough, that the reaction to misdemeanour is very fast and very draconian. You see it, if you want to look at the current example, Texas. Texas having really, really strong results on rehabilitation of offenders with believe it or not in Texas, non-custodial punishments. They don't have prisoner votes at all. I think this is something not really very important to a prisoner. What matters to a prisoner is getting a job, getting a house, having a community around them. You have to reinforce those things. This is the end of the queue.
I spent 7 years responsible for the prison service in England and Wales, and I've been in more prisons than I care to remember. And in all the conversations I had with
Not a common brag.
all the conversations I had with prisoners, not once, did a prisoner ever, of his own volition, raise the issue of his loss of the right to vote. They've got, as David said, their preoccupations are much greater, and the issue of rehabilitation is not to do with whether they exercise the right to vote in prison. It's to do with sorting out their heads and discovering that there are other people in the world apart from them. That's the absolute fundamental. Having a job and having somewhere to live and straightening out their personal relationships.
We did, as a committee, visit High Down and Downview prisons last week, and it was really unanimous amongst the prisoners we met that they should have the vote, all of them.
I said that spontaneously.
Yeah, but yes, it was.
Yeah.
We did ask them the question. It wasn't a spontaneous request. Lady Gibson.
Thank you. Obviously, we have to come to some decision about disenfranchisement or not, as the case may be. There's been a number of criteria presented to us as to what we should consider when we're coming to the conclusion on that issue. And I wonder if you could tell us what you feel about whether the length of sentence should be considered, whether there should be a schedule of offences, and if so, what type of offences, if we're going along that route.
Baroness Gibson, as I understand, obviously, that part of your remit is to look at how the law is changed so that some prisoners are enfranchised. As David and I, Mr. Davis and I have said, we think there's a prior question here, which we hope that your committee will deal with, which is this issue of the jurisdiction of the court, which is fundamental, and I don't personally think can be ducked. I mean, as it were, as a technician, and in some sense I'm endorsing what I'm about to say, but as a technician, I'd say that if the law were to be changed, you need to have a simple change. Because you're dealing with hundreds of courts and thousands of magistrates, and also hundreds of judges. You could have a schedule of offences, one way of dealing with it, but schedules of offences turn out to be pretty arbitrary at the margin. The alternative is to do it simply by sentence length, which is very clear. And bear in mind, this has also got to be clear to electoral registration officers and their staff.
Yeah, I mean, like Jack, I mean, I would vote for a 0 anyway, but I don't see much merit in going down the specific punishment for specific types of offences route. One of the things that's been said by previous witnesses is that the court objects to the automaticity of the arrangements and the indiscriminate nature of the arrangements. Well, turn it on its head. It's normally said that predictable law is good law. You know, so that's the other side of automaticity, really. Also, this is a seriousness issue, not a specific to offence issue. So if you did go down a route like that, I would go with length of sentence, frankly. My view is that if anybody's done something sufficiently serious to go to prison, and it has to be pretty serious, there are plenty of convicted burglars out there who've not been to prison. You know, it has to be pretty serious. That's the threshold. That's why I'd go 0.
Well, thank you.
Thank you very much. Crispin Blunt.
The truth is, there is a democratic override, isn't there, which is secession.
Do you mean secession from
the treaty? To see from the treaty, to withdraw from the treaty.
Throw away all the good bits because of one bad bit.
I don't see it as a democratic override. It's not a democratic override in the terms in which David and I have spoken, or which is recognised in any other jurisdiction in the world. Democratic override means that in respect of this judgment, by this court, it is possible for the democratic institutions to override it. So, take an example, Mr. Blunt, I'm sure you'll be aware, when the law lords came out with a decision in Davis, which was to declare that anonymised evidence, taking of anonymised evidence in the criminal courts was unlawful because there was no statutory base for that. Right? I, with all-party agreement, introduced emergency legislation to override that judgment. And far from the court complaining about it, in the sense they almost invited us to do so. That's a specific case. So withdrawing from the convention, I mean, it's not an override at all. It's, if I may say so, based on a false analysis of how an override would work.
Well, no, yes, surely it is, because what the court was set up to do in the first place was to try and establish across Europe a set of human rights standards. And it was, you know, if you like, the policy intent behind the United Kingdom signing up to it was surely to try and deliver better human rights standards, in particular behind the Iron Curtain, where there were precious few mechanisms for trying to protect people's liberties there. And so that this was trying, so the wider purpose, strategic purpose, was to raise human rights standards across the continent. And so we signed up to a European set of standards.
Well, we did. We drafted them, but we drafted them with our eyes open about what they meant and what they didn't mean. And just to come back to Mr. Gibb, to your point about how things have changed since the 1940s, things have not changed since the 1940s on the fundamental point of the Convention of the Court, which is that the state should not treat people arbitrarily or in a nasty way, and particularly should not place them in a position where their life or their person can be violated. And the issues of, say, deportation of terrorist suspects are the same today as they were 50, 60 years ago. That's what it was set up to do. It was, no one has yet been able to point, David or me, to any text which suggests that we knew that this court was going to extend its jurisdiction in this way and set itself up as a Supreme Court of Europe. There are no texts, and this is therefore a matter of profound concern, not just to people like David and I and the majority in the House of Commons, but many senior jurists in this country. I enumerate some of them in my Hamlin lecture, and many jurists across Europe as well.
There is I'm happy to say there's a division of view on this. That's why we're all here. But the fact is, human rights, standards of human rights, have changed over the course of the last 6 and 7 decades, and it would be surely unreasonable to expect a European court trying to establish continental standards of human rights, not then to change with it.
Then have a new treaty.
Well, that's fine. But that's the democratic override, is to say this is no longer working. It's not.
The mechanism you choose is not one of a set of judges with very different experience. I'm not commenting on their quality, but different experience, to set standards for all countries with different systems, different judicial systems, different democratic systems.
But therefore there is, in that sense, a democratic override, because if it's done its time as an institution because of the way it's operating, it's then what you're suggesting is then to secede, to seek a new treaty, a new convention, setting up a new court.
You can't have it both ways. People have said that us standing back from this judgment affects our reputation. Then would have a very interesting view, I think, on what complete withdrawal would do to our reputation. I actually don't think that what we've done so far does anything harmful to our reputation, but I think pulling out and putting yourself in the position of the Greek colonels or the Belarus would not be clever.
Well, surely it's also not clever then to, if we're on the wrong end of a judgment from the court, which the popular opinion in this country and therefore parliamentary opinion in this country doesn't like. Well, that's actually the purpose of the court, is to try and raise...
That's a criterion you pick. That's not the criterion we pick. Otherwise we'd be here talking about abacadabra. Much more contentious issue in the public eye. This is about extending beyond what it is our right to do. Full stop. And the treaty does not give them that right. The Vienna Protocol, the Vienna Convention does not give them that right. Full stop.
Well, in which case...
So they are the ones who are not respecting the rule of law.
And what's really interesting is that whenever we raise this, we do not get an answer from them. Never.
Never. We tried.
We've tried so many times. David and I actually went to Strasbourg for private meetings with the senior judges there. They don't want to engage on this because they know there are no texts by which British people, British Parliament, has consented to this extension of jurisdiction. It's a problem for them. They've got to resolve it. And they could have resolved it, as indeed the senior judges in the court advised them to do, by extending the margin of appreciation. I mean, there's a wider issue. I mean, in my view, they should have resolved it by saying, not that there should be a margin of appreciation of this, but it's basically out with our jurisdiction. Anyway, they chose not to.
But given that there is this, you've said this, the most important issue here is the constitutional one, and whether the development of the court's practices are therefore consistent with, in effect, our democracy and the rule of law within the United Kingdom. Surely this isn't a very good issue on which to test the importance of this constitutional arrangement, because you've just said to us that actually, in practical terms, the issuance is not going to likely to change the election of a single member of Parliament if prisoners were enfranchised. There is an argument in counter to your point that it wouldn't actually change. It wouldn't be a single fewer criminal offence, I think you said in the debate. As a consequence of this, and there is a perfectly respectable argument to say that attitudes to prisoners in custody, actually treating them as citizens, trying to work them back into society, of which this is, if you like, at the very least, a symbolic way of saying you have not lost your civic rights by custody, and we're preparing you for your return to society, and all of that then goes actually to make it more likely that people will be successfully rehabilitated. That those are a perfectly respectable set of arguments. That this is actually not very good ground on which to fight this extremely important constitutional issue. Well,
it's perfectly good ground for several reasons. Number one, the fact that it may not affect the general election outcome is neither here nor there. This is about, as I said, the social contract that our people have as arbitrated by Parliament. Secondly, you've had Dominic Raab in front of you, talked about the travel préparatoire and the exclusion in the main convention of universal suffrage. This was thought about then and excluded. And I'm afraid that this is exactly the right issue to take this on. And also, frankly, it is not overridden with the sort of storms of public opinion that an issue like abacadabra would have. This is actually quite a cool issue, cool in the old sense, not the modern sense, and not a hot issue. And therefore it's a good one to have this argument on.
I mean, isn't your thesis really that you don't like supranational courts because no supranational court will have a democratic override? And as we are moving into an increasingly globalised world, we're going to have more, not fewer, supranational courts.
Mr. Gibb, I say in the Hamlin lecture that we may not like supranational courts, but if you take the European Court of Justice in Luxembourg, you can't complain about the fact that it has rights to override British legislation. We've signed up to that. It's very straightforward. It's in the 1972 Act. And there you go. And you can argue, as indeed former President Herzog does, about the extent of its judgments, but that's what we signed up to. And there's a very straightforward way of dealing with our obligations under the European Union treaties. If we don't like it, we withdraw. And that's indeed an option which is being debated at the moment. But say, just to repeat ourselves, this is not the case with this.
Yeah, and it's simply untrue to say that we don't approve of international courts. A lot of our conflicts between us were resolved by international courts from one another. The DNA cases and so on were. It's entirely proper to have a court override of a government, but I don't think normally, there are exceptions, a court override of a parliament.
Thank you very much. Lord Peston.
I'm really a bit lost now about what your position is. Jack, you said the court has to change, not us. I wrote that down. And that reminds me of my academic days. Postulate the impossible and see what happens. You know full well the court is not going to change. The court, we appeared before the court, we felt that they shouldn't have been hearing the case, but we did appear. Then we lost. I think cynically, if we'd have won, we'd have said how great European justice is, but that's by the way. We lost. We then appealed to the chamber, and we lost. Therefore, the position we're in is a position that the court has decided something, and we have to decide what to do. Now, it may well be, and that's why this committee exists. We've got to make some recommendations to the government as the government's response to the court, and that's it. Now, you may be right that when this is all over and done with, for those of us who are still alive, we could go to our friends in Europe, if we've got any, and say that it's a fundamental constitutional question that still lies before us, which arises from this case, and we've got to look at what the ECHR should be doing. And you could argue that as a fair point, and I well understand that, and it would have then, we hope, the House of Commons behind it and that sort of thing. But that's, in my understanding, nothing to do with now. What's to do with now is that, and if you've presumably read the government's paper that was submitted to us, which seems to accept that we've got to make a rational response to the status quo. And what we're trying to get from you, and after all you have an enormous amount of experience in this area, is to help us to get to a response. Don't forget, for our response to have any value, it's got to be one we all agree. That's another problem which we have, which you don't have to deal with. We've got to have agreed response, otherwise that'll get nowhere. And what we were hoping from, I mean, one expected you to argue your case, but as two experienced senior politicians, what we really need from you is to guide us towards the rational response at this stage that we can agree on. Without you agreeing, I'm not saying you should agree with it at all, but I mean, some guidance, in my opinion, will be very helpful.
Well, can I just pick this up, Lord Peston, because I believe that the response that Dave and I have is entirely rational. We may disagree with it, and I don't accept for a second your premise that this has been decided in Strasbourg. Strasbourg has spoken, and that's the end of it. I mean, it's not like that, and we've already seen, David said, a significant shift in opinion by that court. All right, this is a quasi-judicial, quasi-political court. It is not. I mean, I think the great error that is sometimes made in the United Kingdom is to see this court as composed of people of the same quality, for example, as our United Kingdom Supreme Court, acting within the same kind of entirely judicial concepts. It's not true. They may claim that to be the case, but they are of variable provenance, the judges, variable quality, and there is some politics there. And I come back to the point that Lord Irving made, where he draws attention to the fact that precisely because of all that, the implementation of its judgments is a matter for the Council of Europe. It's a political process and not a matter of judicial process. So, and they have got to think through what happens where they come out with judgments which are beyond that which is accepted, consented to by individual parliaments. What happens next? And as I said right at the beginning, Mr. Gibb, if I had put this to the British Parliament for a vote, perhaps I should have done in 2007, the result would have been a raspberry. Okay? I would have been overturned. Well, this is, if you like, a force European court meeting an immovable object, and which has higher authority. My suggestion is the British Parliament.
So can I challenge another of your premises, Lord Peston, that nothing will happen with the court? Firstly, we aren't the only people in Europe who have concerns like this. I mean, Jack just referred to Herzog. Herzog was the head of the German, this is not some ordinary German politician, he's the head of the German Constitutional Court before he became President of Germany. And he is really concerned about this constitutional problem. Some of the other governments are too, on different issues, not on prisoner votes particularly, but on different issues. And that's why both the Brighton and Izir protocols were implicitly critical of their own court. So there is a receptive atmosphere there to the arguments we are making. Now, it won't happen quickly. This will take probably a decade to get anything to actually happen, but we're talking about international courts, and they take a long time. Now, in terms of your recommendations, let me just say to you what I've said to government ministers privately, but I don't see any reason why it should stay private. It is important from the government's point of view in this dispute, because that's what it is, that they behave impeccably reasonably.
Yes.
Which means they must put all the options in front of the House. They must not whip the vote, because it must be a free view of the House. It mustn't be the executive's view imposed on the House. And then when the Parliament decides, my hunch is it will decide for zero change, but when it decides, it will then be Parliament challenging the court, not the government challenging the court. Because I don't think governments should challenge the court. I think parliaments should when it's relevant. So, in terms of advice, every reasonable option should be put before the House. That's what the government should do. That protects its own integrity, its own adherence to the rule of law, and its own responsibilities to the House of Commons.
Yes, well, I understand that. Could I just ask, you did say Parliament, so their lordships should also be asked whether they approve.
Yes,
and you would weigh that in the
Well,
vote.
we have no choice. That's a sovereign.
Can I just make this?
I mean, it's not a bad point.
Well, it was over
I agree with the point. I agree with the point.
Subject to the Parliament Act. But the Lord Roger, who Lord Preston will recall, was a senior member of the United Kingdom Supreme Court Law Lord, very distinguished jurist, British jurist. In a judgment called AF number 3, 2009, roundly complained about the attitude of the Strasbourg court, and he used a Latin tag saying Argenturatum locutum judicium finitum. Strasbourg has spoken, the case is closed. And he was saying that was the attitude that was taken by Strasbourg. Now, interestingly, Lord Nicholas Bratzer, who was president of the court at the time, came back and said, brilliantly Latinized as was the sentence by Lord Roger, this is not the way in which I or my fellows view the respective roles of the two courts. So Bratzer himself was accepting that what Lord Roger's complaint, in a sense, hit the target, but he accepted, I think from what he was saying, that they were bound to be involved in much more of a negotiating position when it came to their judgments, compared to an individual court in an individual country, precisely because they are supranational, and precisely too, because they lack the widest possible consent for the jurisdiction they've taken on. And I commend what Lord Roger's judgment, and also Baroness Hale made a really important contribution to this debate, where she talked about Argenturatum locutum is the Supreme Court supreme, and went on to discuss various aspects of the interaction between the Strasbourg Court and our Supreme Court.
Thank you very much. Just picking up on your point about not whipping either house, won't Strasbourg take the view that the government needs to lead on this and not hide behind the skirts of Parliament in avoiding the issue?
I suspect they'd have to make all their ministers vote the way the court recommended, but not beyond that.
Okay. So if we were to recommend even one day, a prisoner serving less than 2 days can have the vote, you wouldn't be prepared to compromise on that? in order to deal with this issue with Strasbourg? Because you see this as a greater point of principle beyond the actual issue of
Yeah, I mean, put to one side the practicality of it.
Yes.
Yes, I think so. Yeah.
Yeah,
But that's my view. But you know, we aren't all of Parliament. You know, we're just us two.
I mean, look, in practice, for people with sentences, very short sentences, unless their incarceration happens to coincide with election day, it is zero effect anyway. Unless it's the first Thursday in May, it's unlikely to be much effect.
Thank you. Have you finished, Lord Preston?
Yeah,
Thank you. Lord Norton.
Going back to the substance of the issue rather than the constitutional dimension. Now, Mr Davis, your argument was that essentially that those who break the law should therefore not be entitled to choose those who make the law.
Yeah.
Now, the problem with that, of course, is not everyone who breaks the law goes to prison. So why does the cut-off apply the moment they're sent to prison?
Well, there's a seriousness threshold, and the custodial sentence passes that threshold. Now, this is rough and ready. You know, there's no theoretical basis for them being the same, but it's an easy way to do it. And we've had 4 representations of People's Act in the last century, something like that. And no point has anybody ever thought to change it. So.
But if we take that line, then you've conceded it's rather arbitrary what the cut-off point is. Your point is that it should now be the point at which you go to prison. That's not always been the case. We've not always had a blanket ban. That's a relatively recent innovation. So
since we've had universal suffrage, I think we've had a blanket ban.
No, since the late 60s. So why, therefore...
Oh, that's right, yeah.
So why, therefore, should we not say, well, it should be at some point in terms of the length of sentence, rather the point at which someone is sentenced, or the logic of your argument would go even further back the moment you break the law.
Well, in theory,
you
you could go back. I wouldn't, frankly, because I think what difference would it make to somebody who's been fined and put on a non-custodial sentence to take their vote away? Not a great deal. It's the inverse of the argument on rehabilitation. I don't think it makes much difference to rehabilitation. Neither I think it makes much difference to the imputed punishment. No, I think it's very simple. You know, custodial sentence is a serious crime. That's enough to justify taking the vote away. Full stop.
I mean, and in practice, the ban has existed since 1918, as you know. It was sort of modernised in 1968, following a 1968 Speakers' Conference.
But the point is one of principle. I mean, if you're saying you break the law, you should lose the right. You're now saying, well, no, some who break the law don't lose the right. It's the point at which it's the point at which it kicks in, and therefore there's no basic principle.
I think there is a principle, and this is why the Strasbourg Court were wrong to use this suggestion of blanket ban, as if it was kind of brainless ban. What Parliament has said successively is that we defer to a court on the issue of seriousness, that there is a point of the seriousness of the offence beyond which a person's right to vote whilst the punishment is taking place should be denied him. Parliament has said that point of seriousness is the point where they go into immediate custody. And we defer to the courts. I don't think that's arbitrary at all.
And the distinctions of remand, fine default, contempt, recognise that.
So really, it's a judgment call at what point it becomes an offence. So it's not actually whether you break the law, it's at what point, how serious the break in the law is. So one could say, it could be up to Parliament to decide when actually a year, 2 years, the cut-off point comes in.
To just repeat myself, I mean, if the British Parliament decided this voluntarily, fine. I may disagree, but this is I'm afraid at the heart of it, as I think we've tried to explain, the issue is the constitutional relationship between this Parliament and Strasbourg.
But that only kicks in once you've got a dispute. My point is, what is the actual reason for the dispute? And therefore we need to have a very clear case, which at the moment seems to be, oh, well, they're in jail, they shouldn't have the vote.
Well, that's our view. It's been an all-party view. Absent the adverse decision in Hurst, it would have stayed an all-party view.
Thank you very much. Derek Twigg.
Just to follow quickly from Lord Norton's view there, just so I understand this, what you're basically saying, if someone is sent to prison because they haven't paid the debts, then tough, but actually someone who might have committed assault but doesn't get sent to prison, that's just unfortunate that they don't get deprived of the vote.
Yes, Mr. Twigger, because I mean I mean I think the chance of somebody being sent to prison these days for debt is minimal, but people are sometimes jailed for contempt, and certainly fine defaulters, or for example, I mean people on remand who are unconvicted, and I don't think anybody argues that those people should be denied the right to vote because they have to be treated, and they are quite properly treated as innocent until they're convicted. But otherwise, yes, what we are saying and what successive governments and parliaments have said is, if you are incarcerated for a criminal offence, for the time of your incarceration, but only that time, you lose the right to vote.
I understand that, but that's the question. Do you think it's fair that situation? Is it just tough, it's the way of life? And
no, I know. I think it's entirely fair. It goes back to David's point about a contract, and I certainly think that my voters in Blackburn understand that and support that and think that it's fair dues. It's about this contract as citizens that we have, and want it to be maintained.
Okay. I just want to go on to this issue about legal advice, because someone who starts in his position is starting from actually being against it, someone opposed to prisoners having the vote. I also have a concern about, well, if I vote that way, am I breaking the law? And I noticed that in your paper, Jack, which was the 10 years Human Rights Act, 10 years on, is that you make some very interesting, well, it's a number of interesting passages, but you say that there seems to be an intellectual fear of lawyers amongst those who are not lawyers, certainly in politics and in the public sector. This produces an unhealthy deference to legal advice, and you go on, in fact, you describe some advice maybe as balmy. Now, as a former minister, I can understand some of the sentiment there, but on that basis, in the retail view, so we have a lot of eminent people in both houses here who actually think we would be breaking the law, and we have an obligation to that. Do you think that's balmy or somewhat off the planet? Let me just quote one for you, because Lord Goldsmith, who obviously is very eminent and very respected, he said, when he came here, he said that first of all, the United Kingdom will be in the clear breach of its international obligations. And he goes on and says there's a significant number of cases that are now being lodged for compensation, and there will be no defence in these cases. What's both your views on that?
Look,
because you're saying they've gone too far, and yet we've got legal advice saying actually we're going to break the law. Yeah.
It sort of begs the question of what are our international obligations. And this is at the heart of this argument. What David and I are saying, and I say I wait further and better particulars from the other side, still not forthcoming, is that we did not sign up to be obliged to allow the Strasbourg court to get into this kind of area. That's at the heart of it. The court has asserted that we have an obligation, but we never signed up to this obligation, and we never consented to it. And this runs into one of the important aspects of the rule of law, which is that it's a two-way street. It depends fundamentally on consent. Now, again, to repeat ourselves, we have signed up to the Strasbourg court adjudicating over whether a deportee should be sent to a particular country. That's very straightforward. We may not like the judgments, but we've signed up to them. We have not signed up to this kind of area. Apologies for a piece of modern technology.
It's not Lord Goldsmith. No, I understand, but the point is we have here, Lord Goldsmith and many other eminent people who've said, both here and in public, that actually we're in breach of our international obligations. How can we have sort of two polarised views like this? You yourself are a lawyer, so...
No, I know, but I mean, two lawyers, three views. I mean, I'm happy to pass on to you the various other jurists who I quote in my Hamlin 2 lecture, and particularly to say that, I mean, look at what Lord Hoffman was saying, look at what Lord Irvine was saying about how these things are resolved. I want a resolution of this, but it will be in any event a political resolution. That's always bound to be the case. I also just add, parenthetically, Mr. Twigg, that unless my memory is playing tricks on me, my clear recollection when I first looked at the papers on this in 2007 was that I was told that we would be in for hundreds of millions of pounds of compensation awarded against the state in the British courts. I said to officials and co, well, we'll see the parties in court. In fact, has been to the British courts, and the British court have been absolutely clear that no right to compensation lies in the British courts. That's just one example of where you can have a very great dispute about legal advice and its consequences.
You're right that there's different views, but the simple truth is the rule of law is not the same as a rule by judges. The judges themselves have to obey the law and the rules. And what the European Court has not done is interpreted the treaty that we signed, the convention that we signed, in accord with Articles 31 and 32 of the Vienna Convention. So that's the problem. That's where the core of the problem ends up. They've done something outside, something ultra vires in effect, in our view. And end of argument.
Thank you very much. Stephen Bryan.
My sincere apologies for my lateness elsewhere. I was in Texas last week with the Justice Committee looking at their criminal justice reforms, which are tough but reforming, and I can tell you, and working. And I can tell you, they were. I explained to them about this committee. They were, let's just say, bemused that we could be in a position where we are in this situation. But they are keeping thousands of people out of jail who would otherwise be incarcerated and therefore lose the franchise, who have the franchise because they're going to drug court every week instead of being incarcerated. So they've made that decision, but that was a domestic decision for them. Following on from what Lord Rock said, we have already made the distinction, of course, in that people who are on remand, who clearly not given anything but in non-payment of fines, still have the vote. And although it has to be said in everyone I've talked to in prisons and people who've come here, the issue of actually voting when they're in prison, it's hardly something that they're banging on the government's door about. But I just wonder, do either of you have any truck with the view that, with the argument that we want prison to be a place which reduces recidivism and turns out better citizens who feel more connected to society, not more cut off from society, and that extending the franchise to them, those on short-term sentences, which, as Mr. Straw rightly says, would not be huge numbers. But do you have any truck with the view that extending the franchise might produce better connected citizens when they come out? Or is that a woolly, silly liberal view which we should just
No, I wouldn't categorise it in that way. I don't think it's particularly salient. And in any event, since the length of term of time that someone serves in prison, for most prisoners, is partly dependent on their behaviour. I think that if you're saying this as an incentive to rehabilitation, which at the margin it might be, then to say to somebody, well, if you behave in prison, you'll be able to get out, say, on a tag, when you've only served a quarter of your sentence, and then be able to vote. That seems to me to be much more practical than saying to them, we'll give you a right to vote in prison. I mean, so that's my view. Of course, I'm very strongly in favour of rehabilitation, and since I'm now indirectly married into the Lone Star State, because my son married a Texan, and we're coming to know the country, a separate country it is, interested in the Texan example.
Yeah, I broadly agree with that. I mean, I'm very much in favour of using prison and or non-prison sentences to rehabilitate. But as I suspect you'll have found in Texas, the successful rehabilitation programs depend on pretty tough and pretty rapid response, and quite sizable penalties for misbehaviour at the end of the day. And in that sort of spectrum, the prisoner vote is down at the sort of tiny end. So I don't think it would have any effect at all.
Okay.
Thank you very much. Hasn't the debate moved on from the European Court of Human Rights, given that the principles of the ECHR are embedded now in European Union rulings, and given that European Court of Justice rulings are directly enforceable by the UK courts, isn't that the issue now, rather than the European Court of Human Rights?
No, I don't think so with respect, not in this kind of area. This is very much a Strasbourg area.
Although it may be going that direction in the very long run, which actually adds a little more urgency to solving these treaty problems before we get there. Otherwise, we really will have a constitutional crisis.
Super. Well, on that note, gentlemen, I think I'll draw the committee's proceedings to a close. And just to say thank you very much indeed to both of you for the time you put in to giving evidence to our committee, and indeed the time you put into this whole issue. I think Parliament owes you both a great debt, and this committee owes you a great debt as well. Thank you very much.
Thank you, John.
It's nice to have it put in that way. Thank you.